Good morning everyone. Today we will be presenting a case under the Innkeepers Act 1952, an important piece of legislation in the Malaysian hospitality and tourism industry. In this presentation, we will focus on a real legal case, which is Premier Hotels India Berhad versus Ling Seng 1995, which highlights how the Innkeepers Act is applied in a real-life dispute. My name is Nur Hazra binti Muhammad Nizam and my number metric is 302294. Let's begin by briefly reviewing the background of the Act. The Innkeepers Act 1952 is a Malaysian law that sets out the duties of hotel owners or innkeepers to keep guests and their belongings safe during their stay. In the section 4/1 says a hotel is not automatically responsible if a guest's things are lost or stolen. The hotel is only liable if the loss happened because of the hotel's negligence or failure to take reasonable care. If a guest is careless with their valuables, the hotel may not be responsible. But if the hotel does not provide proper security or ignores safety rules, they can be held liable. In short, this law protects hotels but also makes sure they take reasonable steps to keep guests and their property safe. So let's move to the act of the case. So now let's look at a real-life example related to the Innkeepers Act 1952. In this case of Ling Seng versus Premier Hotels India Berhad, this issue was about hotel responsibility for a missing car. Ling Seng was a guest at Premier Hotel in Malaysia. During his stays, he parked his car in the hotel's parking lot but one day he discovered that his car had disappeared. It was stolen from the hotel's premise. Tang decided to sue the hotel. His claim was based on negligence. He argued that the hotel failed to provide proper security in the parking area. According to him, the parking lot was not secured. There was no security guards, no CCTV, and no proper gate or surveillance. In response, the hotel referred to Section 4/1 of the Innkeepers Act 1952. They argued that they were not liable unless the Tang could prove they were negligent. The key issue here was whether the hotel had taken ordinary care to protect the guest's property. If the hotel did not provide a reasonable level of security in the parking area, then they could be held responsible under the Act. This case highlights how important it is for hotels to maintain proper safety measures. Even though the law protects them, hotels must still act with reasonable care to avoid being held liable in court. So let's move to the next section.
I will continue to the next point. Now, let's look at the main legal issue in this case. This centers around the question of whether Premier Hotels India Berhad was negligent and therefore liable for the loss of the guest belongings. Specifically, Mr. Ling Seng, after he reported his room key missing and the hotel failed to take adequate steps to protect his room. To put it simply, the core of the case is about hotel responsibility. When a guest reports a missing key, it's not just a casual complaint. It potentially signals a breach of security. The hotel then has a legal duty to act promptly and reasonably, such as by offering a new room or changing the lock. In this case, the argument is that the hotel did not act, or at least did not act reasonably after being informed of the lost key. And because of this inaction, Mr. Tang's room was left vulnerable, which ultimately led to the theft of his personal belongings. So, the legal questions we are examining is, did the hotel's failure to respond adequately amount to the negligence under the law? And if so, should they be held responsible for the loss incurred by the guests? This sets the foundation for the rest of our analysis, which we will break down into the sub-issues on the next slides. Building on the main issue, we now break it down into 4 sub-issues that help us analyze the hotel's potential liability in a clearer, more structured way. First, we have duty of care. Here we ask, did the hotel owe Mr. Tang a duty to protect his property once he reported the lost key? According to hospitality norms and legal expectation, the answer is likely yes. Hotels are expected to ensure the safety of their guests and their belongings, especially when informed of potential risk. Next, we consider breach of duty. Even if a duty existed, did the hotel fail to take reasonable steps to fulfill it? For example, did they ignore his report, delay changing the lock, or fail to offer him another room? If yes, this would amount to a breach. Third, we examine causation. Was the theft of Mr. Tang's belongings a direct result of the hotel's inaction? If we can link the hotel's failure to the actual loss, then the chain of causation is established, and this becomes a strong point for negligence. Finally, we assess contributor negligence. Did Mr. Tang himself do something or fail to do something that contribute to the loss? For instance, did he delay reporting the key loss or leave valuables unsecured? If the guest is partly at fault, the hotel's liability might be reduced. Each of these sub-issues must be carefully analyzed to determine the hotel's overall legal responsibility in the case. That's all from me. Thank you.
Hi, my name is Ahmad Mukris bin A. Rashid 292439. I will presenting the case of this hotel. In this case, the court found the premier hotel liable for negligence after a guest slipped and was injured due to a slippery floor on the premise. The court emphasized that the hotel owed guests a non-delegable duty of care. This means the hotel is directly responsible for maintaining safety and cannot shift that responsibility to others. Here, the hotel breached that duty by failing to take action to prevent a foreseeable hazard. As a result, the court awarded damage to the injured guest. The judge reasoned that the risk was foreseeable and the injury was directly caused by the hotel's failure to respond appropriately. This case would reinforce an important legal position. Hotels in Malaysia must actively prevent common risks like slippery floor, or they can held legally responsible for any harm caused.
Good day everyone, I'm Krishna Devi and my metric number is 290290. Today I want to explain about the rationale of holding in this case. In this case, the federal court placed strong emphasis on the legal duty of care that hotels owe to their guests. This duty arises not only under the common law principle, but it also reinforced by Section 4 of the Innkeeper Act 1952, which outlines a hotel's responsibility to protect the belongings of its guests. The court highlighted that guests who stay at the hotel have a responsible expectation of safety both for themselves and for their personal property. This includes car parks and in areas managed or controlled by hotel, such as designated hotel parking lot. Because of this, the hotel was expected to take adequate steps to prevent theft, such as providing security measures like surveillance, guards, and control access. Although premier hotel tried to rely on a disclaimer notice that claimed they were not responsible for any losses. The court found that this notice was not clearly brought to the attention of the guest. It was either placed where it could be easily missed, or the wording was not specific enough. Under the law, for a disclaimer to be valid, it must be explicit, reasonable, and clearly communicated to the guest at the time of check-in or before the property is left in the hotel. Furthermore, the court emphasized the existence of an implied contract between the hotel and guest. This means that by accepting a guest, the hotel is also agreeing to provide basic level of care and security. A guest should not have to worry about their vehicle being stolen while it is parked on the hotel premises. Because Premier Hotel failed to meet this expectation and did not take sufficient preventive measures, the court ruled that the hotel was negligent. Their failure to act reasonably in protecting the guest vehicle resulted in legal liability, and the disclaimer could not protect them from that responsibility. Thank you. That's all from me.
In conclusion, the case of Premier Hotel Siddham Berhad is a key decision that emphasizes the legal responsibility of hotel to ensure guest safety. The court held that hotel owe a non-delegable duty of care. This means they cannot transfer the responsibility of maintaining a safe environment to third parties like cleaner or contractor. The hotel is directly accountable. In this case, the wet floor was a foreseeable hazard, yet the hotel failed to act. This inaction amounted to a breach of duty, and the court found the hotel negligent. As a result, the injured guest was awarded damage. This reflects the legal system firm stand on hotel guests from preventable harm. Overall, this case set a clear legal precedent in Malaysia. It reminds all hotel and similar business that the guest safety is a legal obligation, and failure to prevent obvious risks can lead to liability. That's all for us. Thank you.